Welcome to the Half Empty, Half Full Consumer Advocacy Radio Show. Listen in nationwide on the Tan Talk and Starcom radio networks with your host, Lori Zook, the consumer champion. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to learn something new. Get smarter faster and avoid scams and fraud. All opinions are that of the host and guests, and all shows are for educational purposes only and not to be construed as legal advice. Here's your host, Lori Zook.
And welcome to the show. My guest today is Bob Hurt. Bob is a consumer advocate, and he's been on the show before. And as a matter of fact, Bob, your show on Rogering Judges was the highest listened to, highest podcast hit of all the shows I've ever had combined. So people were really interested in that topic. So in today's show, we're going to be talking about what you as a consumer need to know about legal malpractice in the context of foreclosure defense by lawyers. And we're also going to be discussing on how judges can be sued, or rogered is the term that you use. So I want to welcome you to the show and just share with our listeners a little bit about yourself and your background.
Well, I appreciate the opportunity, Lori. My background is fairly varied. I spent a lot of years in the United States Navy and in the computer industry. And after retiring in 2002, I decided to take up a study of law issues, an independent study not associated with any law school or attorney program. And so that's what I do. I read up law issues and write commentaries about them. They're available in the articles section of bobhurt.com. That's BOBHURT.com. And also, with respect to the mortgage industry, they're on my blog, bobhurt.wordpress.com, and as well on the website I've devoted to Mortgage Attack, which is mortgageattack.com.
Gotcha. Okay. And nothing you're giving today is to be construed as legal advice. You were going to just be going over the educational stuff because people find this of interest. I want to start in this segment with legal malpractice. And in the context of foreclosure defense, I know this is, you're going to give me a big answer, but give me a definition of legal defense in the context of mortgage foreclosure.
You're talking about legal malpractice?
Yes.
Well, legal malpractice means failure to perform a legal duty that a lawyer has with respect to a client. It's just another category of professional malpractice, such as medical malpractice and so forth. But the idea here is that in a mortgage dispute, which is a contract dispute, the attorney for the defendant, who is the mortgage victim or the foreclosure victim, has a legal duty to provide a good defense for breach of contract disputes. And if he fails to provide that proper defense, to do his homework, so to speak, even though he may disclaim his obligation, he still has the obligation. And that means that it's worthwhile in some instances to take him to court and sue him over it, and at the very least to file bar complaints against him.
Okay, now, why don't most lawyers examine the mortgages? You know, these real estate foreclosure pretender defenders, I know that we refer to those terms a lot. Why don't they examine mortgages and appraisals and instead just utilize delay tactics? Doesn't that hurt the homeowner?
It might hurt the homeowner and it might not. But let's take a look at the grand scope of the problem. The problem is that the borrower typically has breached his note. He has failed to make timely payments. And he executed both a note and a mortgage security instrument. In some states, there is a judicial foreclosure process like Florida, where the lender has to sue the borrower, or the creditor has to sue the borrower in order to get the foreclosure. But in other states, non-judicial, there's no lawsuit necessary. There's a trustee for the purpose of foreclosure, and he will foreclose and cause a sale of the property in order to pay the creditor back. But with respect to the attorney's why they don't bother going through the arduous process of investigating every single aspect of the loan and of all of the activities associated with that loan and all the documents associated with it. It's because it's a lot of work to begin with. It takes 40 to 50 hours to do a proper mortgage examination. And most attorneys not only don't want to spend the time doing it because they can't get the $12,000 to $15,000 they'd want for such work from a typical foreclosure defendant. And the second reason is they found a better way to make money.
And I'm going to agree with you on that because years ago when clients used to call me, I'm a credit consultant, so people would call me sometimes in tears going, oh my gosh, my credit's destroyed because of this foreclosure, and I was trying to find a way to help them. The odd thing was I would get calls from people who said, well, I have an attorney. Now, my first thought is before you hire an attorney, you should do due diligence, check out that attorney, find out what is their track record as far as winning. And I would say, well, how many cases has your attorney won? And the comment was always the same. What do you mean? Well, how many cases has your attorney won in foreclosure court? What did they actually win if they're claiming that they won? Because that definition is different, correct? Some will say a win is I beat them in court for a stall tactic type of thing versus winning, which to me would be either getting some type of money or winning the house. So I would see that a lot. And you hit my next question, which was, is it because attorneys want the monthly retainer money? Or is it because they don't know how to attack the mortgage? Or is it both?
Lori, there's a combination. I mean, there's really no excuse for an attorney who is an expert in the law not to know the law. However, the body of laws associated with mortgages boggles the mind. It has such a gargantuan dimensions. We're talking about tort law, contract breach law or contract law, mortgage law, and then all the associated federal regulations, not to mention debt collection law, credit report law, and so forth. The lawyer should be familiar or have familiarization with all of these, but many of them simply do not. But the real reason that they don't examine mortgages is partly because of the term I would refer to as Kool-Aid drinker.
Okay.
And that's taken from the terrible Jonestown slaughter of 900 people by having them drink Kool-Aid because they thought there was some religious advantage or benefit to it. Well, foreclosure pretense defense attorneys are Kool-Aid drinkers to some extent because they actually believe that the only thing they can do for their clients is to lead them by the hand, step by inexorable step, to foreclosure and loss of the house. And so what they do is they put up a smoke and mirrors defense that doesn't rely on the injuries that the borrower has suffered from the lender, but rather lies on the mistake the lender makes in the foreclosure process, such as failure to perform the conditions precedent to foreclosing, such as, for example, to give a proper notice of acceleration of the note and making it all due and payable at one time. So what the typical attorney does, a foreclosure pretender defender, is that he uses the identical pleadings for every case, changing only the names, and mounting the same objections or, let's say, defenses to the foreclosure attack, and litigating each one of those as necessary to drag the proceeding out. For this privilege, he will charge $300, $500, $1,000, $2,000, $5,000 down as a retainer, and then $300, $500, $1,000, $1,500 a month for as long as he can keep the client in the house. And he thinks that by being honest with the client and letting the client know that he is eventually going to lose the house, that's good enough. But it really isn't good enough, because he does owe the client, when the client comes to him with a breach of contract dispute, he owes it to the client to look into that contract and to its provisions and to the circumstances surrounding it in an effort to determine whether the borrower got injured by the lender, the mortgage broker, the appraiser, the realtor, some lawyer, the title company, or some other third party. But they don't do that because it is a lot easier to earn the money with cookie cutter or copy machine pleadings, which are just copied from other cases. So, Lori, I want to address your comment a moment ago. You said, how many cases has the lawyer won? Always ask this question when you go to select an attorney. Yes, what you have just pointed out is that the biggest problem people have with legal malpractice is they fail to select the right attorney. And what you should ask them is, will you show me the answers to the complaints that were filed for your last 3 clients that had a case similar to mine? Because if you look at those 3 answers to the complaint, you will probably see that they look identical except for the name changes. And if they do, that means the lawyer's using cookie cutter pleadings.
All right, and obviously that's no good. They're not looking specifically at your case. They're just doing that stop and stall. And that's what concerns me. I mean, is a lawyer obligated to answer questions as far as their track record if a client asks? And I would assume it's a bad sign if the attorney doesn't want to do that.
I'd say it's a bad sign if the attorney balks, acts indignant. I mean, nothing wrong with asking an attorney, look, do you have malpractice insurance? Oh, yes, the lawyer will get indignant about it. What do you think I am, a crook? Well, yeah, I think there's a strong possibility you might be a crook. How am I supposed to know? Attorneys are not required by law to advertise their track record because why? Well, for one reason, that every time there's a legal dispute in an adversarial proceeding in court, somebody has to lose. Why would you hold that against an attorney just because his client didn't have a meritorious case?
Right, and I'm going to ask you to hold the thought. We're going to come back with that in just a moment.
Our highly competitive and hectic world is fraught with dishonesty and challenges. Critical decisions must be made on a daily basis with accuracy when substantial assets are at risk. When you are confronted with a decision point involving opportunity and risk, consult with Sharpline Investigations, statewide experts in due diligence, investigations, and litigation support. Sharpline's professionals work with clients to conduct interviews, deep background investigations, and develop facts and intelligence related to litigation. When circumstances require confidential and expert fact-finding, turn to Sharpline Investigations, the statewide leaders in investigations and risk mitigation. Visit sharplineinvestigations.com or call 855-394-0042.
Are your credit reports a mess? Are debt collectors hounding you? Maybe you're in foreclosure or headed towards foreclosure and don't know where to turn. It's time to stop panicking. Take back control of your life. Make the first step by calling Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Mention the word radio for a free 15-minute consultation. Don't delay. Call today.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
Welcome back to the show. I've been speaking with Bob Hurt. Bob is a consumer advocate. And in this segment, we're going to continue a little bit talking about legal malpractice in the context of foreclosure defense. So, Bob, can a homeowner sue the agents of a bank for fraud or racketeering?
Well, yes, the homeowner can, and that is the ideal aspect of a foreclosure defense. One doesn't need to go into foreclosure to have a reason to sue someone who injured him. But since most of the people never think about having a contest or a fight with the bank until they get faced foreclosure or they're dealing with a difficult problem having to do with the servicing of the loan, they never think about such a thing because they want to get on with their lives and live a happy, prosperous, fulfilling, productive life. Unfortunately, their attention gets drug away from that by losing their job or facing some difficulty makes it impossible for them to make timely payments, or listening to a Kool-Aid drinker who says, you don't need to pay that loan, there's no money to borrow anyway, and your note funded the loan, and crazy things like that.
Well, wait a minute. The most common thing I heard was that the bank would tell the homeowner, we can't help you until you've missed 3 payments. Well, what homeowners didn't realize was by missing 3 payments, you just dropped your FICO credit scores 1 to 200 points. What are your chances of getting a loan modification or any help at that point? But they were listening to the other side tell them what to do, and then in the end, you know where it all went. They lost the house.
Yeah, and the problem with that is the statute of frauds. Under the statute of frauds in every state, there is a specific limit on a court's ability to enforce a contract that is not in writing. It's typically $500 in value or more than 1 year in duration. A contract not in writing, in other words, an oral agreement, which is what we're talking about with these loan modifications, the contract becomes unenforceable. It just becomes a he said, she said fight. And if you were to take it to court, and of course the judge is going to look at the homeowner as trying to get a free house, regardless of his real excuse. So the problem here lies in the fact that the people in the mortgage company, the bank, who are talking about, or the servicer, who are talking about a loan modification and the requirements to miss payments in order to qualify for the loan mod, are simply telling you, hey, why don't you breach your contract?
Right. And they were telling them what to do so they would win.
Right.
You don't talk to the other side.
That's right. They're telling the borrower to breach the contract because if you pay a note either 1 minute late or 1 penny short, you can get foreclosed on. And while they might want to work it out with you because it could be disadvantageous to the bank to foreclose, you might also have a lot of equity in your house, and it could be very much to their advantage to force a foreclosure sale. So don't become a penny late and don't become 1 second short in making your payments, ever, if you want to keep your home.
Okay, now I'm going to bring it back here to the legal malpractice part. Let's say you hired one of these attorneys and you feel that maybe there was some type of legal malpractice. Can you sue the attorney for legal malpractice?
Well, you can, and when you sue an attorney, first of all, you're walking into a minefield, and you could get your foot blown off, which is simply a euphemism for saying you're not an expert in the law, and the attorney is. So when you go into a contest with an attorney, you're going to make sure that you have your own attorney to do this. Now, most attorneys will not take a legal malpractice case if they don't see crystal clear, clean-cut, hardcore legal malpractice that's indisputable. They don't want some wishy-washy maybe. They want an absolute certainty that this lawyer really cheated or injured the borrower by failing to perform a legal duty the borrower had every reason and right to expect. Well, that means that most legal malpractice issues boil down to a case within a case. That means in order to prove legal malpractice, you have to show you got injured. And that the injury was a result of the lawyer's failure to do a legal duty. Well, in a mortgage foreclosure case, if the borrower breached the note by failing to make timely payments, what did the lawyer do to cause that problem? Nothing. So therefore, it's not the lawyer's fault if you lose your house. In fact, I would point out that most people who have breached the note haven't a single leg to stand on. They're going to lose that house, and they ought to lose it. That's the reason you sign a note, and that's the reason you sign a mortgage security instrument, is to make sure that if you breach it, they can force you to give up the house by going and taking you to court. So the issue here is that if the lawyer failed to examine your mortgage instruments, all the documents related to that mortgage and all the circumstances surrounding it, looking for how the borrower got injured, then that failure could have resulted in the borrowers losing the house to foreclosure, not because the borrower didn't breach the note, but because the lender breached the note first, or let's say the appraiser. And here's an example. Okay, if the property gets appraised for $400,000, but it was only worth $230,000, that's a $170,000 overvaluation. That is fraudulent. And it's fraudulent inducement for the mortgage company, the bank, who underwrites this lousy appraisal, to encourage the borrower to borrow the money because the house wasn't worth that amount of money to begin with. So that kind of fraud would justify suing the appraiser and the lender. Well, if the attorney, the foreclosure pretender defender attorney, doesn't undertake such a lawsuit, or at least advise the client he should do that, and I'm talking about the borrower client, then he has committed legal malpractice, but only if the borrower loses the house. So the borrower has to suffer an injury because of the failing of the attorney in order to justify suing the attorney for legal malpractice. And what was the injury? The injury was he got foreclosed on and he had to give up the house when the injury was so bad that was caused by the appraiser that he could have got the house free and clear, or at least gotten monumental compensatory and punitive damages. Since the lawyer didn't go after him to get those damages, that lawyer committed legal malpractice. So that is how far you have to go to be able to prove that the attorney didn't do his job.
Okay, now, suing an attorney, I would think it would be difficult to find another attorney to sue an attorney, especially they all know each other. And I'm assuming that there are probably specialists that do that type of legal work. What about the bar? Do they do anything if a consumer complains to the bar?
Well, you do have a reason to complain to the bar if the attorney does not do what he agreed to do. You know what? I encourage every citizen to read the rules regulating the bar of your state. In Florida, that's the rules regulating the Florida bar, and you can find them at floridabar.org. Those rules regulating the Florida bar explain that an attorney has to, for example, exhibit candor to the tribunal. If an attorney lacks candor, if he omits to tell the court something important and material, if he tells the court something that's simply incorrect and he knows it, he needs to have a chance to correct it. But he could be disciplined for this, and discipline means sanctions. So I would say one of the biggest problems that people have when they deal with attorneys in court, attorneys who do dirty, rotten, no good, scoundrelous, scurrilous things, is they fail aggressively to hold the attorney accountable by asking the court to sanction the attorney for breaching the bar rules and showing contempt for the court.
All right, now this is where I say the consumers should be doing their due diligence before they hire that attorney. And there are websites, like I'm familiar with avvo.com, where you can check out, you can type in the name of the attorney and see if they have been disciplined. And then I would assume you could probably contact the bar to find out what the discipline was for. I'm not sure on that part, but you can tell whether or not they've been disciplined. Now, we've got like 2 minutes before we go to the next break. So I want you to just tell me a little bit about your blog and your mortgage attack page.
Okay, well, I have established a website called mortgageattack.com, mortgageattack.com. I put it there to provide information to people, to let them know the kinds of arguments that the courts have rejected when dealing with foreclosure issues. And I'm talking about arguments by the defendant, the foreclosure victim, that there are certain arguments that simply fail all the time. And they fail with good reason because they're bogus and they were never sensibly put forth to begin with. And in addition, to explain what does work in dealing with a foreclosure issue, to either stop the foreclosure process or to win damages or to justify negotiating a settlement with the lender so that the foreclosure will come to a halt without court action.
All right. Now, you provide all this information for free, correct? You're not working as a lawyer. You're providing educational information. It doesn't cost anybody anything to look at your information or maybe forward your information to their attorney if their attorney isn't that knowledgeable.
It's absolutely free. And in addition, I have posted a dozen or two articles that I've written going into some depth in some of these issues, showing why certain efforts have proven fruitless and why a person shouldn't bother trying to make those same kinds of efforts because the courts rule against them. And yes, this could be extremely valuable to attorneys who sincerely want to help their clients and don't want to engage in legal malpractice.
All right, very good. When we come back from the break, we're going to talk about suing judges. Stay with us.
Are your credit reports a mess? Are debt collectors hounding you? Maybe you're in foreclosure or headed towards foreclosure and don't know where to turn. It's time to stop panicking. Take back control of your life. Make the first step by calling Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Mention the word radio for a free 15-minute consultation. Don't delay. Call today.
Our highly competitive and hectic world is fraught with dishonesty and challenges. Critical decisions must be made on a daily basis with accuracy when substantial assets are at risk. When you are confronted with a decision point involving opportunity and risk, consult with Sharpline Investigations, statewide experts in due diligence, investigations, and litigation support. Sharpline's professionals work with clients to conduct interviews, deep background investigations, and develop facts and intelligence related to litigation. When circumstances require confidential and expert fact-finding, turn to Sharpline Investigations, the statewide leaders in investigations and risk mitigation. Visit sharplineinvestigations.com or call 855-394-0042.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
Welcome back to the Half Empty, Half Full Talk radio show. I've been speaking with Bob Hurt. He is a consumer advocate. In this last part of the show, the last half hour of the show, we're going to talk about suing or rogering judges. Now, we did a show on this before, and you had incredible information because, hey, most of us didn't even know that you could do something like that. So first, can you define what a judge is? You know, are they elected or appointed officials?
Yeah, a judge is a constitutional officer. And that is, the office of judge or justice has been established by the Constitution of the state and the Constitution of the United States. then there is a process that is either constitutional or legislative defined for putting judges into office. There are two ways to do it. One is election, and the other is appointment. And some elections simply choose to retain a judge in office. But in the state courts, the judges are appointed by the governor. And the governor can appoint replacement judges when a judge dies or just decides to run off to Tahiti to learn French. And
You're making me laugh. Okay.
And in federal courts, the federal judges, of course, are appointed by the president, and their appointment is confirmed by the Senate. But in Florida, we also elect judges here and retain them for elections ordinarily through the electoral process.
All right. Now, there are canons of code of judicial conduct. Can you kind of give me a definition of what that means?
Yes. The Code of Judicial Conduct is created by the Supreme Court, and you can get a copy of it at the Supreme Court website, FLcourts.org. There are 7 canons in the Code of Judicial Conduct, and these canons are, I guess you'd call them advisory in nature. Elected judges the law requires elected judges to sign a statement saying that they have read this Code of Judicial Conduct, so at least they have awareness of it. But as far as I know, there is no law requiring them to abide by it. It's simply, I guess you'd say, advisory. Let's face it, judges are the mothers and fathers of society. The churches have pretty much fallen down on their role in managing and keeping family morality together and encouraging people to do the right thing and so forth. So judges have taken over that role to a large extent in family law especially. But the Code of Judicial Conduct tries to ensure that judges understand and the public understands what they should expect from judges. Just because they're so-called the parents of society and they have the power to hurt people badly, even though the people don't deserve to be hurt, we have reason to expect judges to exhibit propriety, common sense, dignity, show respect for the law themselves by abiding with that law. So these canons' purpose are to ensure that. Canon 1, a judge shall uphold the integrity and independence of the judiciary. You know, the Constitution establishes the judicial branch of government as independent from the legislative and executive branches. And that means the governor doesn't have the right to come in and tell a judge what to do. Even the Supreme Court justices as individuals don't have the right to tell a circuit court judge what to do. They can do it through a proper judicial order process, but they can't just lord it over them in any other respect.
So it's, in other words, it's separated so that there's no conflict of interest. Is that what you're kind of trying to say?
I'm saying that it's, yes, they're separated so that there won't be a conflict of interest, but a judge might have a conflict of interest in some individual case. For example, what if he's doing criminal cases and he owns the jail? Maybe that kind of judge shouldn't sit in a criminal proceeding because he has a vested interest in the client going to jail. I mean, in the defendant going to jail.
I'm going to throw something to you then. A few months back, I heard a case. I don't recall the case, but it was one where it was a foreclosure case, and the defendant's counsel found out that the judge had some type of retirement fund, I believe, or a mutual fund with one of the big banks, and was able to get that judge to recuse himself. But how many times does that happen where you don't know about it? And does that play on the judge's mind that, wait a minute, I'm investing money in this company, I'm counting on them to foreclose? Do you see what I'm saying?
Yes, well, I realize that could seem like a conflict of interest. Personally, I don't think it is. because an individual foreclosure case will not affect the bank whatsoever. The typical bank on an individual foreclosure is not going to be bothered by it. And if a judge owns shares in that bank, I think it's irrelevant. But if there's another judge available, and I think the Supreme Court has spoken to this back in the early 1800s, if there's no other court, no other judge available, I'm sorry, that judge has the job to do, and he's going to do it. So we just need to, buck up and take it. A judge shall avoid impropriety and the appearance of impropriety in his activities. What's impropriety? It's doing things that don't look right, misbehaving, running around with wild women, for example, getting drunk publicly. Those are improprieties. Having big gambling debts, that's an impropriety. Canon 3, a judge shall perform the duties of office impartially and diligently. If there's a canon the judges violate, I think they violate this one more than any other, because right or wrong, when a defendant or a party is standing in front of a judge and he makes the judge mad, the judge is human. And if he gets angry, he's going to make it more difficult for that party. And therefore, he is going to exhibit prejudice. There is no way a judge can be expected to be impartial to a person standing before him looking for the judge to function in his office. When that person misbehaves toward the judge, he comes into court looking bedraggled and disheveled. He speaks with slang and curses. He stinks of alcohol and weed and things like that, or he just simply behaves sullen and disrespectful to everyone. Maybe the guy has a reason to feel that way, but regardless of that, you're standing before a judge with the power to throw you in jail. What kind of fool would do that?
A lot of people would do that.
Unfortunately, a lot of people do, because they've been told by Kool-Aid drinkers that judges are all bad and the courts are all crooked. They're not all bad and the courts aren't all crooked. And I would venture to say that even a judge who is crooked is only crooked sometimes, that he's honest most of the time. He may have his crookedness, but unless he's got some particular influence from bribery or favoritism for somebody that's a litigant somewhere or for some attorney, I don't believe the judges are generally prejudiced. There's no reason for them to be. Canon 4, judges encouraged to engage in activities to improve the law, the legal system, and administration of judges. Well, judges do this all the time. They give public speeches, and they go to the law schools, and they encourage people to have respect for the law, and they participate and give their advice to lawmakers, and so that laws can be made that are good. Canon 5, a judge shall regulate extrajudicial activities to minimize the risk of conflict with judicial duties. Hey, I'm sorry if there's a funeral in the family, but that doesn't mean you have to run off when you've got a big trial coming up. Find somebody else to go in your place or somebody to stand in for you as judge. And if you can't do it, do your best. Anyway, Canon 6, fiscal matters of the judge should be conducted in a manner that doesn't give the appearance of impropriety. Look, a judge shouldn't buy an interest in the jail, okay? He shouldn't own an interest in something that is guaranteed to give him a conflict of interest. A judge or candidate for judicial office, Canon 7, shall refrain from inappropriate political activity. Yes, judges should behave in a nonpartisan way, because it doesn't want to, they are nonpartisan officers. They get elected without standing as a Republican, Democrat, Independent, or anything like that. And that would be a clear example.
All right. Now, I want to talk about judicial prejudice. Give me an example of judicial prejudice.
Well, one example would be that the judge owns interest in a bank in a foreclosure proceeding, and a big interest in that bank, and the bank is a party to the dispute. The proper judge would recuse himself from this and let other judge take it. But another issue would be, say this judge is married to a defendant's former mother-in-law. that kind of gives them sort of a remote family connection. And if the judge had reason to dislike the defendant from some family dispute issue in the past, he's likely going to rule against him and be hard on him, even though the merit of the dispute shows that the judge should go the other direction.
I gotcha. All right. Well, we're going to take a quick break, and we come back. We're going to talk about disqualifying judges.
My friend.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
Our highly competitive and hectic world is fraught with dishonesty and challenges. Critical decisions must be made on a daily basis with accuracy when substantial assets are at risk. When you are confronted with a decision point involving opportunity and risk, consult with Sharpline Investigations, statewide experts in due diligence, investigations, and litigation support. Sharpline's professionals work with clients to conduct interviews, deep background investigations, and develop facts and intelligence related to litigation. When circumstances require confidential and expert fact-finding, turn to Sharpline Investigations, the statewide leaders in investigations and risk mitigation. Visit sharplineinvestigations.com or call 855-394-0042.
Are your credit reports a mess? Are debt collectors hounding you? Maybe you're in foreclosure or headed towards foreclosure and don't know where to turn. It's time to stop panicking. Take back control of your life. Make the first step by calling Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Mention the word radio for a free 15-minute consultation. Don't delay. Call today.
Hello, I'm Jim Velasquez. Does getting a lousy 1% on your CDs make you sick to your stomach? Inflation is hovering at 3%, so what's really happening? Allow me, Jim Velasquez, to send you my free report. If you haven't reviewed your CDs in a while, don't get this report. It will break your heart. If you want to fight back and beat the bank, text RETIRE to 72727 for this free report. Let's beat the bank. Text RETIRE to 72727 for your free report.
My friend.
Welcome back to the show. Bob, I want to talk about rogering judges because we spoke about that on a previous show. Talk a little bit about the term rogering judges.
Okay, I will address it in this way. There was a case, Rogers v. State, many years ago in Florida, in which the Supreme Court gave a new trial to a criminal defendant who had actually murdered an attendant in a grocery store. There was no question that he had murdered the attendant, but the judge in the original case had rushed the case to a final judgment of guilty and had colluded with the prosecutor in doing this. Public defender stood up and disputed it. Now, Florida rules of judicial administration and Florida Statute 38.10 both require that the judge must disqualify himself if a party to the case or the lawyer writes a legally sufficient motion for the judge's disqualification, stating prejudice as the cause and giving the specific reason and behavior that made one think the judge was prejudiced. So, in the case of Rogers, the judge the public defender did submit such a motion, and it was legally sufficient, but the judge argued against it and said, wait a minute, I'm not prejudiced. Come on now.
So you're saying that the judge actually can come back and fight what that motion was for?
If he does, he's wrong. Because if the motion is legally sufficient, the law requires the judge approve the motion. And the judge did not approve it. So as a consequence, the public defender appealed the conviction, and the appellate case went to the Supreme Court. The Supreme Court overturned the conviction and required a new trial. Well, okay, the guy got convicted in the new trial, but at least they gave him a fair trial. It isn't fair when a judge shows prejudice against a client or against a party to the proceeding. So that not fairness, that prejudice is what you asked about before the break, and now here we deal with it again. The issue of this Rogers v. State opinion is that attorneys can use that opinion, or so can litigants, in any case where they suspect the judge of partiality rather. Judges should be impartial, as you know from the canons we read, but if they show partiality to one side or the other, such as giving one client or one party to the case a very difficult time, even though the client does a good job, and not saying anything to the other party when they do a bad job, that it clearly indicates prejudice. Now, rogering the judge, that term simply means to bring up the Rogers v. State opinion as a basis for challenging the judge's authority. Now, I would say the best way to do this is to file a motion for the judge's disqualification, stating the reason that you feel that you can't get a proper hearing, a fair hearing, and that reason being because of the judge's prejudicial behavior. Now, if that motion is legally sufficient, the judge must disqualify himself, but what judges have done throughout Florida in recent years is to simply rule that the motion was not legally sufficient. In that case, a person should file a petition for writ of prohibition to the appellate court and demand or seek in that petition to have the judge disqualified. In others, to prevent him from proceeding in the case.
Now, what are your thoughts on lawyers that maybe have developed, I don't want to say relationships, but it seems to me that lawyers, when they know, for example, in foreclosure cases, that they're getting a particular judge, they're happy. And then at other times, they're disappointed, depending upon who the judge is. So what does that kind of say about the system?
Well, what it says is that people develop a reputation and a feeling of comfort working with some people more than with others. Like, I have to tell you, Lori, I feel a lot more comfortable with you in this room right now than I would with my ex-wife.
Okay.
That ought to be a good example for you.
Okay.
But the people that you've had a good success with, for whom you have developed respect because you admire their perspicacity, their integrity, their honesty, and the common sense that they exhibit, you enjoy being around those people and working with them to a common good end.
I get what you're saying. So it's not necessarily favoritism. It's that the lawyer knows that this judge is going to give them a fair trial, so to speak, or a fair opportunity, versus when they're disappointed and they go, oh, no, this judge tends to rule in this particular way regardless.
Yeah, that's right. But if they do get the feeling that a judge is going to go in a certain direction regardless, let's talk about foreclosures being one of the main points here. You know, in a foreclosure issue, there's usually no question that the borrower breached the note by failing to make timely payments. Okay? If the borrower breached the note, what is the judge got to do? The whole purpose of the mortgage instrument is to say, hey, if you breach the note, we're going to have to force a sale of the house. Who's going to force that sale? The judge. Because he has to apply the laws unless you find some way to show that the bank breached first, correct? Right, but if you don't bring this up, if the defendant never brings that issue up or his attorney never brings it up, then what is the foregone conclusion? Is the judge prejudiced for every single time saying, I'm ordering foreclosure, you got 60 days to get out, get your stuff out?
Maybe it's because the attorney did not do their job.
That's exactly it. The attorney didn't do his job. That's not a prejudiced judge. That's a judge doing what he ought to do.
All right. Now, I want to talk a little bit about the article you wrote back in 2009 based on the book Suing Judges and How to Bring Judges to Justice. So kind of just give me a quick summary of that article.
Well, the point of my reading the book was to read what this one scholar had to say about it. And I have sad news to report. And that is that his conclusion, or the conclusion one must come to after reading such a work, is that it's a very hard expectation to have that a judge will get thrown out or punished by a court that you sue, in which you sue the judge for some crime or some evil thing. In other words, what is a judge going to do? He has to exhibit tortious conduct or malfeasance of some kind in order for you to sue him personally for compensatory or punitive damages. You're going to have to prove that you got injured. Now we've got back to a case within a case situation again. Did the judge do what was wrong? Well, he has a lot of leeway for discretion. There's ministerial duties, there are administrative duties, and there are judicial duties. Judges have judicial immunity for their judicial acts. They cannot be sued for violating, for breach of a judicial propriety because, hey, that's what judging is. It's guesswork. It's trying to think, what's the right thing to do here? What does the law really mean? And issues like that. Now, if a judge is required to fill out a particular form and he doesn't do it, if he is required to, issue a certain document and he simply refuses to do it, those duties that the law requires don't cut him any slack. If he doesn't perform and obey, and that injures the party to the case, then that party has a good reason to sue him. And so you can't sue and get away with suing judges for their judicial acts, even though they're wrong. But you definitely can sue a judge. But look, that's like, are you going to sue your mother or your father? I guess not. That's what it boils down to. What are you going to do? They're going to make mistakes. They're human.
Right. Well, I've found this to be very interesting in talking with you on it again. I want to thank you for joining me today. And if you wouldn't mind giving out your contact information one more time in the event somebody wants to contact you.
I will. The name again is Bob Hurt. My phone number is 727-669-5511, bob@bobhurt.com. And don't forget mortgageattack.com. But I want to end this with one final comment. There is no substitute for learning the law. If you get burned in court, it's probably because you deserved it.
Got to do your due diligence. Well, thanks again, and join us every week for a new half-empty, half-full talk radio show. Learn something new, get smarter faster. Be safe.